As Professor Biller already indicated, we are, my topic of today is a kind of a subset of issues on an initially theoretical level, the legal status of military space objects, and whether we talk about combat spaceships or combat satellites or what have you not. One of the reasons why I thought this would be interesting to make this comparison is that the comparison is often made, but not always with, I dare say, sufficient understanding of the true nature of the comparison and the extent to which these things are comparable, which is where I hope to be able to shed some lights. So if you ask why is that important, I think the fundamental reason is that the legal analysis of many aspects of military activities hinge on legal status of objects, on legal status of persons, whether that is under general international law or even under LTWRC specifically. I will focus largely on LTWRC to the extent that there is a lot of LTWRC applicable to the issue of status of the objects involved in those activities. When it comes to LTWRC, and I made that pitch already earlier on when I had the honor of almost a year ago of speaking at the inaugural conference of the Space Force on this object in more greater detail, and those of you who were with me may recall that I did mention that LTWRC has an important role in outer space and the possibility for military conflict to erupt in outer space as well. But that at the same time, we should be careful with just assuming that all LTWRC can be one-on-one transposed into outer space. Most of LTWRC is domain specific, meaning that it has been developed specifically for warfare on land, in the maritime areas, later in the air, and then of course most recently also in cyberspace. We've seen separate conventions on already going back to 1899 and 1907 in The Hague on warfare on land and warfare on sea. We saw later things like the Harvard manual on LTWRC specifically applied to air. And then more recently, of course, there's the Talon manual, which is kind of a point of departure of discussing LTWRC in the cyber domain. At the same time, already when I mentioned that most of LTWRC is domain specific, of course, that means that not all of it is domain specific. And there's certainly some LTWRC, which even upon closer view is non-domain specific, although much of that is at the same time not so specific in a number of other ways as well. I'm going to focus largely on two sets of LTWRC regimes, if you will. One is very much focused on UN Charter, which in many ways is currently the heart of LTWRC, you may say, at least guiding and dictating much of the more detailed applications. And in particular, of course, the Charter obligations on armed attacks against the state and the right of self-defense of a state, or the possibility to use armed force in the other crucial area allowed by the UN Charter, which is UN sanctioned or even mandated use of force. And then beyond that, there are some of the general LTWRC principles, which I will also say at the outset are in principle applicable to outer space. But the question is, how exactly? And that's also where the issue of status, I think, plays an important role. So, of course, the four classical principles are military necessity, distinction, or sometimes it's called discrimination, the issue of proportionality, and then finally the element of unnecessary suffering or humanity. And I apologize for the small spelling error there. So starting with the UN Charter, Article 2, Paragraph 4, of course, talks about the baseline prohibition on the use of force, but it reflects, it limits that, at least as the Black Letter Law determines, against the territorial integrity or the political independence of a state. And as we shall see, that already brings in a little bit of an issue on status. The other main article of the UN Charter is the right of self-defense, where there is a semi-automatic relationship. If you are attacked by use of force as a state, as a UN member state, then obviously you have the right to defend. The use of an armed attack, the context of an armed attack, the terminology of an armed attack has been referred to elsewhere, and I won't go into great detail here. That's why I underlined the UN member state, because again, that raises some issues when it comes to space, because obviously the Outer Space Treaty, as most of you are aware, but I just want to make sure that everyone is aware, provides most fundamentally that there is no territorial sovereignty in outer space. The Outer Space Treaty, of course, the seminal 1967 treaty, which regulates all activities in outer space, doesn't in principle make an exception for military activities, and we will come to that. That's part of the problem, if you will. But if you talk about an attack against a state or the territorial integrity of a state under the Charter, or the right of a UN member state to defend itself against an armed attack on the member state, then we should realize that there is no territorial sovereignty in outer space and that there is no member state in outer space. So the question then arises, what does that mean? What is the effect of these fundamental LTWRC provisions on the allowable, respectively prohibited use of force on Earth? How does that translate to the space law context? And for context, the Outer Space Treaty is currently ratified by 111 states, and the number is growing by the year, I would say. Those include obviously all the important major spacefaring countries, so we can really say that it is the applicable law to outer space. And the overarching question, which I already discussed at a larger level of abstraction in my talk last April, is then, of course, how does that relate to LTWRC? One of the consequences of Article 2 is also that Article 1 provides for free access to all areas of outer space for all states, which is again a clear confirmation that you cannot exercise, no state can exercise territorial sovereignty, any exclusive jurisdiction over any part of outer space. And that, of course, raises the issue to what extent an armed attack on something in outer space, whether it is an establishment on the moon or Mars, or whether it is a satellite, qualifies in the context of the Charter for the applicable rules. At the same time, the UN Charter is not negligible from the perspective of space law. As a matter of fact, Article 3 of the Outer Space Treaty provides, of course, that the UN Charter applies to outer space, in particular in the domain of international peace and security. The caveat I have to make there, however, is that Article 3 is certainly intended to mean, to serve as a kind of a fallback option. The understanding already in 1967 with the Outer Space Treaty was clearly that it is impossible to arrange for everything up front when it comes to space activities. So if we come up with a legal issue where we don't find a ready-made solution in the Outer Space Treaty, we are entitled to look to general international law, including the UN Charter. But of course, to the extent that the Outer Space Treaty or other space treaties do not provide for different legal answers and solution. And there is an inherent conflict here, which I just want to put on the table here. We can discuss later the details thereof, because at the same time, of course, the UN Charter itself declares itself of a higher hierarchical order than the Outer Space Treaty, Article 103, if I'm correct off the top of my head. So if you have a conflict between the Outer Space Treaty and the Charter, does the Charter rule, or does the Outer Space Treaty rule? Because the Outer Space Treaty says in Article 3, the UN Charter only applies to the extent that it does not contradict the Outer Space Treaty. And this then leads to questions like, is an attack on a space object a use of force against the territorial integrity? Where the answer is, in principle, if you look at the Black Letter Law, probably no, unless there is a later development which could be argued to add the quasi-territory of satellites to the concept of territorial integrity. Political independence might be another trigger, of course. To what extent can a state be considered to be politically dependent upon a particular satellite, a set of satellites? But the status focus the focus of the subject of status will focus on the territorial integrity. Related to that question is, of course, then the one of self-defense. If a space object is attacked, is that akin to an attack on the UN member state itself? And what does that mean for the right of self-defense? If it is, then it seems clear that there is a right of self-defense. But can that right of self-defense then only be enjoyed against another space object of the opposing party, or is it also possible to take different action under Article 51? And question 3 then is going more to a specific space law provision. There's the Liability Convention, which basically says that if you harm another state satellite or if you cause damage to it, you're supposed to pay for it. But how do principles of LOEC interfere in the case that satellite may be a legitimate target for the use of force? And again, you may recognize these slides because I've used them before in the context of similar discussion. But again, the questions that I want to go at here now, behind these questions are questions of legal status. Can a space object indeed be legally equated to a territory in the context of the UN Charter and further and broader law? Can it be considered a member state or part of a member state, so as to directly and comprehensively invoke Article 51? And if it is not, can it still be determined to be essential for political independence? But particularly the first part, of course, relates to the status, the legal status of a space object. And again, as I said, often the comparison, lawyers look for comparisons elsewhere, and it's logical that they look for other comparisons in the maritime law and air law. I'll come to that. But the question is, to what extent is that comparison correct? Can LOEC principles apply to space objects? And to what extent does that depend upon whether the space object has a military status? Does something like a military status officially exist under space law? Or do we have to go back again to terrestrial principles to determine that? Or in spite of non-military status? I don't have to tell you that there are a number of LOEC rules which allow certain action in the context of an armed conflict against objects which as such do not have a military status, commercial ships for one. So, and if that is the case, how? How can they apply? How would they apply? What would be the result? So far for my sort of initial, and I realize I put more questions on the table than giving you answers, but for my initial discussion of the UN Charter as one of the two elements, let's have a look at the other part, the LOEC principles. And again, the four classical ones provide my guideline here. So military necessity can be sort of summarized as meaning that you are allowed to use armed force under international law against military objectives, offering a profound military advantage. Now, the word military is 3 times in these two sentences. So that already raises the issue, what is a military object? What is a military objective? It is clear that if you talk about arms and other military objects, which are clearly of a military nature, which are covered in clothing, which is supposed to be allowed to hide a truck or a cannon or something like that, then it is much more likely to qualify as a military objective, and as a consequence, it's much more likely to be included in military necessity. But that doesn't exclude that also civil objects, clearly not arms as such, although they could potentially be used as arms, could also be part of the discussion, although likely at a much lesser extent. So whether you can define something as military or not already may make a major difference in applying this principle. Second principle of distinction or discrimination should be summarized as the fact that military attacks should be directed in principle at combatants and military targets, and not civilians or civilian property, where again you see the difference between military and non-military states. Now on the left-hand side, you see 4 examples of what as such are clearly not military targets. On the right-hand side, you see 2 military targets and 2 types of individuals which as such may not constitute military appropriate military targets or targets for military attacks. Again, the word military is crucial in the distinction. The principle of proportionality, which essentially means that even though you are able to attack military objects only, you can still cause damage to non-military targets, or I shouldn't say target probably, but military objects or persons. And that is not ipso facto prohibitive of the military attack in the first place. It all comes down to proportionality. The incidental loss of civilian life or injury should not be excessive in relation to the military advantage. That's all probably, again, very familiar with you. But it means that each time you have to make this balance, and in what way you can make the balance is, again, I'm not going into any detail right now. But before you can go into such details in the context of outer space, you need to understand the extent to which proportionality and the distinction between military and non-military objects does apply to outer space to begin with. The fourth one is, of course, unnecessary suffering or humanity, where you talk about the fact that military forces should avoid inflicting gratuitous, unnecessary violence on the enemy and not cause unnecessary suffering. If you look at literature, much of it broadens this a little bit to say that, and that goes a little bit to military necessity and actually also to proportionality, that of course ultimately the effects of any warlike use of force on civilian population and property should be as limited as possible. And again, I want to make the point that this all seems to depend upon the difference between something being considered military as opposed to something being considered civil. So that's kind of the initial, and most of this I'm assuming is already quite familiar to you, although you may see me some of it putting in a new lens or in a new light through a new lens in order to make it more adaptable to the discussion in the context of space. So if we talk about space objects, as already was mentioned also in the introduction, the obvious comparison in terms of military space objects would be with military ships and military aircraft, but I start with the broader approach, with space objects without any distinction between military and non-military, and then compare that to ships and aircraft. And why is that comparison in first instance very appropriate? All three are movable, human-made, what I would call, with a little bit of an ugly word, platforms or vehicles, if you want, capable of carrying humans. And because of that, basically, they can, of course, become involved in military activities, including actual armed conflict, but obviously military activities comprise much more than armed conflict. But of course, at the same time, LTWRC is rather focusing on the latter. But this is why all three can be considered to be a potentially fruitful subject for comparison. Another reason is that as a consequence of their movability, in context of the international legal aspects, they are capable of moving across frontiers from one state into another, or even to international territories, which of course also creates special distinctions in terms of how the law applies, because international law is still very much so focused on the territory where things happen. So a comparative analysis makes sense. And this even goes beyond this sort of practical approach, practical analysis of these three types of human vehicles. Legally speaking, all three are not, at least not inherently, equal to the legal concept of territory. Just to remind us that territory in a legal sense means an area of land, and national territory is an area of land which is exclusively subject to the control of a sovereign state. That's the essence of national territory. Now, of course, we can then include a certain minimal part of the territorial waters. The current law of the sea tells us that there is a small strip outside of the national land boundaries which can serve as territorial waters to a maximum of 12 miles offshore. And even there, the national jurisdiction of the state of sovereignty is exclusive, although there's one fundamental exception, and that's the right of innocent passage, of course. As long as foreign ships comply with the conditions for innocent passage to apply, they don't need to ask for specific permission of the coastal state to pass through their territorial waters, even though in any other sense of the word, they're subject to national sovereignty. If we think vertically, then air law adds national airspace, which is, whether you look at the Chicago Convention or the law of the sea, is the airspace above land and the territorial waters. This is not conclusively defined vertically, because we still have no uniformly agreed upper boundary of airspace, but I won't go into that issue right now. Needs to be noted, of course, that innocent passage in airspace is not permitted. It doesn't exist. That, of course, has to do a lot with the differences in speed. If a ship passes through somebody's territorial waters, you usually do not talk about more than a couple of dozens of miles per hour, whereas obviously aircraft are flying with a factor of 10 or even more faster. But it already foreshadows that we shouldn't be too easy in just transplanting certain rules from one regime to another. The innocent passage regime, which makes a lot of sense in terms of legal control and jurisdiction and status of the area in terms of the territorial waters, makes much less sense in airspace and therefore is not applied there. We spoke a lot about jurisdiction, and if the ships and the aircraft, and then as we shall see also the objects, indeed are not territory as such, legally speaking, that of course does not mean that states cannot exercise jurisdiction over. And here I want to go into a little bit more detail. If we talk about the law of the sea, I start with the ships. Of course, ships can be subjected, and usually are subjected, to what I would call quasi-exclusive national jurisdiction of the sovereign state. I come to the quasi in a second. If you look at the ruling treaty on the law of the sea right now, the United Nations Convention on the Law of the Sea, the third iteration of 1982, this huge convention, in Article 91, it specifically provides that ships can be given a nationality by way of their registration. That creates the concept of the flag state, and the flag state has then exclusive jurisdiction of over that ship and everyone on board and everything happening on board, but on the high seas. And that's a crucial element. That's why a ship does not qualify as territory, but only as quasi-territory. Because as soon as a ship of one state finds itself in another state's internal waters or harbors, it is clear that it is not territorial jurisdiction, but quasi-territorial jurisdiction. Under general international law, the sovereignty of states over their own internal waters and harbor, it means that the quasi-territorial jurisdiction of the flag state then bows comprehensively to the territorial jurisdiction of the state of internal waters or the harbor. And if the visiting ship doesn't want to do so, for example, in case of warships, who do not want to suddenly be subject to a foreign state's jurisdiction just because they're in their harbor, that requires the need for special agreement. And of course, in a special agreement, and NATO is of course a very familiar context in which these kinds of special agreements are concluded all the time. Under that special agreement, the host state can say, okay, I allow you into my internal waters or my harbors under certain conditions, but if you comply with those conditions, I waive my right of territorial sovereignty. I give you a kind of an immunity status. But you need a special arrangement in the internal waters or the harbors. Now, of course, in territorial waters, the situation is slightly different because they are not inside the territorial landmass of a country, but nevertheless, UNCLOS 3 still provides for the ruling of sovereignty of the coastal states. And again, that applies unless otherwise provided and agreed. And basically, UNCLOS 3 itself already then provides for this exception of innocent passage, which I refer to. If a warship wants to cross territorial waters, it may again needs to have a special agreement with the coastal state. If it doesn't want to see the quasi-territorial jurisdiction of the flag state being superseded by the territorial jurisdiction of the state whose territorial waters this concerns. So we really talk about quasi-territorial. Now, how does that work in airspace, in air law? Well, we basically have the same approach. Also, aircraft can be subject to quasi-exclusive jurisdiction. The Chicago Convention, which is the ruling treaty on international air law, talks about Article 7 providing nationality to aircraft as per registration. And although it's not as literally spelled out as in the law of the sea, states without any dispute, without any debate, can then apply their national law on board. At the same time, also in this case, we talk about aircraft being qualifying as quasi-territory, because if aircraft are present in the airports of other states, in the territorial jurisdiction of the other state, the Chicago Convention, many articles of the Chicago Convention, again, subject the right of the flag state of the aircraft to exercise jurisdiction to the right of the state of territory to exercise jurisdiction. Just to give you one example, Article 17 provides for the right to search aircraft of any other state. Again, just to forewarn you, this is kind of the general approach. I'm not yet talking about any military aircraft, obviously. If you talk about states, aircraft, excuse me, in other states' airspace, basically the same applies. The Chicago Convention is full of articles which again clarify that as an aircraft of one state operating in the airspace of the other, you basically have to comply with whatever that other state dictates. The Chicago Convention gives as crucial articles, as crucial examples, Articles 11 and 12, whereby the national air regulations and the rule of the air apply to all aircraft in national airspace, including foreign ones. And another example is the Tokyo Convention of 1963, which deals with criminal offenses on board of aircraft, where you would probably imagine that the state, the flag state of the aircraft is the primary state to exercise jurisdiction, but not quite so. If you look at the way the Tokyo Convention phrases this, it may look like that, but actually Article 4 provides that the criminal law of the flag state can only be applied if the overflown state, the state in whose airspace this aircraft is happening when the purported criminal act takes place, cannot show substantial interest that the act in the discussion threatens the safety or the aircraft or the security of the state, or that the aircraft actually is going to land on the state. So it is really still subsidiary jurisdiction, a quasi-territorial jurisdiction. And again, to make the point, involvement in military operations does not necessarily, by definition, change these baseline applications. You need a specific clause on this to carve out ships in military context or aircraft operating in a military context from these general rules. And the specific carves out can be provided by terms of the relevant treaties. As you will see also later in the slide, the Chicago Convention specifically exempts state aircraft from its own operations, or you need to find a justification in LOAC, where then the treaty should supersede the relevant treaty in the context, at least, of the armed conflict. Let's go a little bit deeper into that. There is some provision in UNCLOS 3 already on how the general application of the convention operates in specific context of warships, namely providing, first of all, a definition of warship, something which you do not find at all in space law, I can already say, belonging to the armed forces of a state. And there's, of course, enough state practice and jurisprudence and general understanding that everyone more or less is on the same page when something is to be considered a warship. And then the consequence of being a warship is that non-compliance by such a warship with the national law of the state of territorial jurisdiction in territorial waters cannot give rise to the normal sanctions of national law, but can only give rise to the need to exit, which of course means that the state, again, of the territorial waters, in order to accept such immune body, an immune vehicle, an immune platform within its territory, over which it is not supposed to entitle any jurisdiction, that it can refuse the entry up front. So certainly in internal waters and harbors, states can simply refuse the entry of foreign warships. Even though they may be immune to legal prosecution, etc., I'll come to that. They are responsible for damage. UNCLOS does indeed explain what sovereign immunity is all about. It means legal immunity from other states' jurisdiction, taxation, and regulations on the territorial basis. And it means that violation against a warship can be considered an armed attack pursuant to Article 51 of the UN Charter. But that really follows from the sovereign immunity. And immunity does not naturally follow from nationality. You need a clause like the UNCLOS clause for it to apply to warships. And since immunity also drives the right of a state to consider an attack on a warship, an armed attack pursuant to Article 51 of the UN Charter, that doesn't follow ipso facto from nationality either. You again need to have this additional provision of immunity. Final set of relevance, or at least there are certainly more, I'm sure, but the ones that I proposed to bring to your attention right now on armed conflict. The ships as military objectives. The Geneva Protocols, additional Protocol 1 is quite clear on that. This brings back the concept of what is a military objective. It's limited to an object which, etc., make an effective contribution to military action and whose total or partial destruction, capture, or neutralization offers a definite military advantage. So that's when a ship, whether it is a warship or not, can, whether it has the status of a warship or not, can still be subject to military action of an opposing party in an armed conflict because of being a constituting a legitimate military objective. Sanremo manual adds then that it certainly includes enemy ships, but even neutral merchant ships can under circumstances be seen as such. So in terms of the status, this doesn't depend upon UNCLOS, this doesn't depend upon being a ship or a warship, it depends upon a very specific analysis of whether something complies with the definition of a military objective. And the question would remain, to what extent could that be held to apply to outer space as well? But you need at least then to argue the military advantage being gained by that. Let's take a comparative look at air law on fighter aircraft. The Chicago Convention, as I already indicated, is not applicable to state aircraft, which certainly includes military aircraft, but it also means that the Chicago Convention, unfortunately, doesn't define military aircraft. In all the treaties, it used to be defined, but that definition is sort of conveniently forgotten, I'm almost tempted to say. But of course, we can still agree basically that aircraft operated by armed forces of a state and bearing military markings are by and large going to be considered military aircraft by anyone around. What that status means is something else. Sometimes you need, or you might need to take the registration in a military register as an additional proof, or an aircraft registered in a civil register, but nevertheless for purposes. I don't want to go into detail, but it is clear that air law as such doesn't provide more than this kind of general approach to what is a military, what aircraft enjoys a military status and what not, and certainly what it means. The nationality of an aircraft, different from the laws of the sea, in terms of military aircraft, because it was carved out from the Chicago Convention, is not specifically addressed. Well, presumably that is clear to everyone. If it belongs to the armed force, making it a military aircraft of a particular state, then obviously it will be presumed to have the nationality. The point I'm going to make is that even such nationality does not automatically give rise to the immunity that we've seen in the context of warships, let alone to the applicability without further ado of Article 51 of the UN Charter. You can't argue that they follow from nationality, even to the extent that you might be able to argue that nationality applies to fighter aircraft. Few words on aircraft as military objectives. There's again this additional protocol, the same article, where again aircraft qualifying as military objectives can be validly attacked. The Hague Rules on Aerial Warfare again provided that the military status is not necessarily limited to fighter aircraft, but civilian aircraft can in certain cases be also included. Although I think it's fair to say that the limitations here are considerably larger before that happens than in the case of warships. But let's omit that and finally go for the rest of my talk basically to how that works in space law. Jurisdiction in space law seemingly starts from the same assumption. Space objects can be subject to the quasi-exclusive national jurisdiction of the sovereign state. The Outer Space Treaty, for starters, in Article 8, clearly provides that registering a space object allows the state of registration to exercise national jurisdiction. And as we shall see, that is presumed to be exclusive in terms of exercising jurisdiction over that space object. Excuse me. Interestingly enough, Article 8 also goes one step further because it adds jurisdiction over personnel thereof, even while that personnel may not be on board of the space object at the moment this jurisdiction is exercised. So one would call it a quasi-territorial plus kind of status, which is, and we can forget about for the time being, I think, in the current discussion, this additional personnel to the extent that the application of LOAC to outer space is an immediate concern given the geopolitical developments. I think it's fair to say that for the next 10 years, it is going to focus on military activities without humans in space being involved. But we can discuss whether that's a really valid conclusion, but that's at least what I'll assume to be the case. Now, as I already indicated, the Outer Space Treaty is further developed by the Registration Convention, which fundamentally provides that no double registration is allowed, which confirms my earlier point that only one state can exercise exclusive quasi-territorial jurisdiction over a space object. One launching state can exercise jurisdiction. Article 2, paragraph 2 actually provides that if there's more than one launching state, meaning there's more than one state entitled to serve as the registration state in principle, they should agree amongst themselves which one should register and which one as a consequence can exercise jurisdiction. Now, before we go a little bit further into this, the definition of space object is important. And we find that explicitly provided for in the Liability Convention, which is another convention developing the Outer Space Treaty in particular detail, and the Registration Convention, which both provide for, well, it's not really a definition, it's rather circular. It basically says that a space object includes its components, parts, and its launch vehicle and parts thereof. So it's probably fair to say that we have to go to an expert definition, going something along the lines of all man-made space objects which are attempted to be brought into outer space. Attempted to be brought, meaning that it doesn't necessarily need that the space object actually is in outer space, as long as the clear attempt to launch it there is present. This raises, but this is a little bit to the side, although later on in the military context, in the LOAC context, this may become an important issue as well. What about object not launched as such into outer space? There's increasing talk about something called in-space resource utilization, which basically means that the idea is not to transport everything you're going to use in outer space from Earth to outer space because of the obvious costs, but that you're going to use minerals, iron, platinum on the moon or on Mars or on other celestial bodies to build your whatever you want to do there, to build it locally. And since if you use platinum from the moon, that is not launched into outer space, anything built from that platinum, at least according to the letter of the law, does not is not included in the concept of space object. So anything I'm going to say about the legal status of a space object may be questionable in terms of application to these later developments. And we probably need at some time either a legal understanding that also such objects should still be read into the concept of space object, preferably by an amendment of the definition, or otherwise at least by an authoritative reinterpretation, or we should define it differently by treaty law, by customary international law, in a way that helps us clarify what the status of such objects would then be under international law, under LOEC, in the context of potentially armed conflict. I will leave that part there and go back to the status issue. Space objects, similar to ships and warships, and aircraft and fighter aircraft, qualify as quasi-territory, because as soon as they are found in another state's legal territory, which in the case of space objects is not likely to happen unless there is an accident, the Outer Space Treaty already indicates that only the ownership is not affected by a return to Earth, which clearly suggests that that if a spacecraft, a space object, somehow lands in another state's territory, the jurisdiction over that space object no longer is exclusive as originally intended by Article 8, because that exclusivity only applies to the outer space object as long as it is in outer space. As a matter of fact, Article 8 adds, to be sure, that that the state where the space object lands shall then return it to the state of registration, meaning that without such an obligation on the Outer Space Treaty, the territorial sovereignty of the state of landing could lead that state to say, well, we keep the space object in our custody, or we do with it whatever we like. And you need this specific clause of Article 8 to again carve out a minimum form of quasi-territorial jurisdiction still being applicable, namely the state being entitled to see the space object return. That is not the same as legal immunity. It may have some elements of it, but it's not the same. And the word immunity certainly is not in there. So continuing, if it's in another legal territory, you have another treaty, the 1968 Rescue Agreement, which provides for further detail. And again, it requires the state of territory of landing to inform, recover, and return to make sure that no hazards are involved, but it is also entitled to receive payment for any of the costs in recovering and returning the space object. So again, the baseline assumption, even under the rescue agreement, is that the territorial sovereignty supersedes quasi-territorial sovereignty, and that this Article 5 is necessary for the state of registration to the launching state to be entitled to certain rights nevertheless. So if we look at further law on space objects, we again will find that nothing refers to immunity, nothing refers to something like a territorial status in the context of the Outer Space Treaty. The Outer Space, in the context of the UN Charter. The Outer Space Treaty, for example, focuses on liability. Article 7 provides that liability for damage caused by a space object should be reimbursed by the launching state or launching states. That's elaborated by the Liability Convention. And as indicated already in one of my earlier questions, question number 3, as such, it doesn't necessarily exclude the application in a warlike situation. You can only argue that LOEC trumps this right to the extent that the damage is caused to another space object of another state, constituting a legitimate military target under LOEC. There is an interesting set of rights already in the Outer Space Treaty to observe the flight of space objects from other states and to visit space objects of other states or celestial body, which is a clear breach of the right, the otherwise applicable right in outer space of an exclusive nature of the state of registration. The Registration Convention requires the general function of a space object to be indicated in the international registration process, which suggests that states are at least incentivized to also register their military satellites, because the original idea of the registration convention is to provide a certain basic space situational awareness set of data, very basic. The idea is that at least you are able to avoid clashes with other satellites if you know that other satellites orbit in certain orbits. And the general function requirement is so vague that you can simply say reconnaissance satellite or even Earth observation satellite if you don't want to call that a military satellite. The word military, the status of something as a military versus a non-military, doesn't work there. Military, actually, only you find the term in a very limited context. The Outer Space Treaty does refer to the prohibition to station weapons of mass destruction, but that's of course far more limited than limiting any military activities per se. Only on celestial bodies, there is a quite strict regime. The term of art is peaceful purposes, but the way that it has been elaborated makes clear that no normal, no standard military activities can take place on celestial bodies. Military personnel can be used only for scientific and exploratory purposes, not for military exercises, military posturing and things like that. But that's basically the only context in the Outer Space Treaty where you find a reference to military. And even the Moon Agreement, which kind of addresses the details of the Outer Space Treaty when it comes to the moon, confirms that. And even though the Moon Agreement is not enforced for most countries, including the United States, this part, this confirmation of the peaceful uses of the moon was not the reason of contention over the Moon Agreement. So we can kind of see that as a confirmation of Article 4, paragraph 2 of the Outer Space Treaty. Otherwise, again, I repeat that, the word military is absent. As a baseline, the regime of outer space law on space objects is applicable to all military space objects, unless there are either provisions in outer space law that specifically, explicitly or implicitly carve out military objects or objects engaged in military activities or even LOAC, number one. Number two, unless the UN Charter could be seen as trumping the Outer Space Treaty in the context of LOAC. Or number three, to the extent that general principles of LOAC could be seen as superseding these concepts. But then you have to make the argument about military necessity, about proportionality, etc., etc. So to sum up, because I see my time is actually already a little bit overstepped, and I hope there's some room for Q&A. Space objects enjoy quasi-territorial status, following from the state of registration, which can then exercise jurisdiction. Quasi-territorial jurisdiction, because it's still overridden by the true territorial jurisdiction of other states as applicable. And space objects do not have a nationality. Even though they can be registered, the word nationality is not in there. And even if you could make the argument that in many respects it is equal to nationality, it does not lead by itself to immunity as a warship or status as territory in the context of the UN Charter. Space law, again, does not provide any special status for military space object. It rather focuses on military activities, and it only confines them in the sense of being prohibited on celestial bodies. The rest of outer space is basically open for any military activity as long as no other limitation would be applicable. The obvious consequence this is of the inherent potential dual use nature of almost all space activities, whereas you can easily imagine a number of ships which could not really serve easily as military objects, and the same applies to aircraft. Think about delta wings or things like that. In space, almost every space object is inherently able to serve for military and for non-military purposes, and we should therefore be very careful in applying any special status. With apologies for going a little bit over time, I stop there. thank you for your attention, and I assume that we still have some room for questions.
Absolutely. Thank you very much for that very interesting presentation. Our first question comes from our friends at the legal office of the 319th Reconnaissance Wing. Does Article 7 of the Outer Space Treaty also apply to damages caused by space debris from destroyed space objects?
Yes, that's a great question. That was discussed relatively early on. And the logic behind that is that if you want Article 7, which is then of course elaborated by the Liability Convention, to serve its ultimate purpose, which is also included in the preamble of the Outer Space Treaty, namely to make victims of space, to give them as much as chance to see their damage compensated as possible. The idea is to apply Article 7 as wide as possible and not limit it to damage caused by live satellites, but also include dead satellites. And because Article 7 also talks about the component parts, and the definition of space object in the Liability Convention talks about component parts, this is kind of a little bit stretched so as to include also broken off parts. So that was a long answer. I apologize for that, but the short answer is yes, space debris does qualify as a space object for purpose of Article 7 of the Liability Convention. The problem is then, of course, that if the space debris is small enough, or if it originates from an original explosion or collision back in time long enough, it may be impossible to actually identify the launching state, but that's more practical than a legal problem, I would say.
All right, I have a question. And keeping in mind what you just said about almost all space objects end up being dual use objects, ships, aircraft, and in fact, most military objects operating in the air, maritime, and land domain have some sort of specific military marking. And often they're actually required to do so under IHL. Should military space objects be required to contain some sort of similar marking? Is this impractical? Would it not even really be helpful? Perhaps some sort of a digital type of marking to identify it as a military space object? Or could something be contained and a registration requirement to identify it as a military object?
That's a great question. And the answer is basically, I guess, that nobody has really addressed that in depth specifically for the military purpose. Because in that sense, the discussion on military use of outer space in a lower context is fairly recent. The effort of the WMRA manual is perhaps 5 or 6 years old, which is, and there was another effort slightly starting before that. So it really hasn't been discussed. And I just want to grab the text of the registration convention, because even talking about the registration of completely commercial or non-military satellites, the registration convention says that an appropriate designator of the space objects or its registration number. So it depends on whether you think it's appropriate to do so. If you don't think it appropriate as a state to give it a designator or a registration number, then the registration convention basically allows you off the hook in that regard. So, and the practice then comes in, the state practice is of course that most states don't even register their military satellites to start with, let alone that they then indicate, hey guys, this one is really spying on you, to put it in plain language, right? I mean, that's a major difference between aircraft and ships on the one hand and space objects on the other hand, going to the practical part of your question, that of course, to identify a space object as a military space object, supposing that there is an identifier, you need a very large telescope to see that. Or indeed, that's why the suggestion you made of an electronic identifier might be very interesting. Of course, that might make things very easy. But then again, you require certainly the major spacefaring nations to agree that this is a good thing to prevent, excuse me, to prevent inadvertent use of armed force against something that one state considers a military satellite just because it isn't certain, and the other state is then very much offended because it wasn't used for military purposes at all. And given the lack of trust and the complications in actually determining whether a satellite is a military satellite or not, and this goes back to the dual use issue, I think states are very unwilling to accept that. I mean, obviously there are ships which look like innocent merchant ships, but can nevertheless have a clear military function. But there's at least a bunch of ships, if they have major cannons on board or carrier aircraft on an aircraft carrier, nobody will, will for one moment think that that's not a military ship. So there is at least a bunch of ships that are clearly identifiable as such. In space, you don't have satellites with guns sticking out or with smaller killer satellites clearly sitting on top, ready to be launched against an enemy satellite. That may happen. I don't know. I'm not an expert.
I was going to say not yet. Not yet.
Okay. Let's leave it at that. Thank you.
Okay. I had a question. It relates to a question in our Q&A. And that's when we think about particular warships and fighter aircraft, we generally don't worry about the principle of proportionality. Unlike perhaps a soldier in a crowded marketplace, generally warships are operating not immediately close to civilian ships, and the same with fighter aircraft. But could a violent kinetic attack on a satellite ever really meet the proportionality principle in space, which relates to one of the questions we had in the Q&A about whether attacks in military space objects can be or could be kinetic, as opposed to perhaps some sort of other cyber operation or it just denies the service of the satellite or space object as opposed to physically destroying it.
Yeah, to start with answering the very first question, yes, in principle it can. I mean, the most clear-cut example is that if that satellite is really used by your opponent in a military conflict to guide its missiles, to put a very clear-cut example, then I think you can argue proportionality, because then it's 100% military, and the direct effects on non-military population or objects or other items is so indirect and so limited that I could see easily that argument being made. There is another point, however, and that goes to the space debris, where you may then question, well, if you blow up a satellite, is it then proportional that you cause so much damage not to civilians of the opposing party, but to third countries who have a perfectly operating satellite out there? And that's why I would think about, well, the least you can do is then make sure, going back to an earlier question of one of the audience, that you could hope to maximize the chances that at least you can find the culprit in the liability convention. Another problem is here that is precisely the cyber element. Satellites, by definition, are guided from the ground using modern communication technology, which already to a large extent sort of could be determined as cyber. So if instead of actually blowing it up, you can reach the same results by controlling it through hacking into the ground station and making sure that the satellite can no longer guide the missiles that we are talking about in our hypothetical example, then the risk of damage of that satellite being caused to other satellites out there is much less so. So in that sense, I would still say, well, you could make the argument, but there are these typical additional space features. One, the environment, if you really blow it up, there's other civil satellites of completely third-party countries potentially involved as well, which technically speaking, the liability convention is allowed to handle, but you never know how effective it is. And second, the cyber element, which is much more prominent in space than in these classical areas, domains of LOAC. And another thing is that, of course, usually the satellite operations are not so clear-cut, that a satellite is exclusively used for guiding missiles. I don't think there's any satellite of which you can say that right now, because it means that you launch a satellite and maybe for the first 15 years you don't use it because you're not in an armed conflict, right? And that brings in a whole host of other proportional issues. Is the satellite being used for less direct military uses, for communication between military forces which do not directly amount to a direct contribution to battlefield operations? Is the same satellite also used for commercial operations? If you look at today's satellites, they usually have dozens of transponders if we talk about the telecommunication satellites. Some of them may be temporarily or for the full time of operation be leased to military authorities, but some others may be leased to commercial operators or for medical purposes or for perfectly peaceful purposes, which would suffer a major blow if the satellite would be blown up. And again, since we have cyber capabilities, if you have the cyber capability not to hack the whole satellite, but just the transponders that irk you, if that possibility is there, just as with the very precise targeting that drones make perhaps possible, does that not also raise the bar for proportionality and making sure that in that case, you are not entitled to blow up the satellite just because 5 of its 20 transponders may do a lot of harm, if you are able to just shut down those 5 transponders?
Right. And it's something we often discuss is, you have to consider the whole element of time as well, that you don't necessarily have to think about with other types of military objects. If you can damage an environment for the next 3,000 years, how do you even incorporate that into your proportionality analysis? It's very
right.
We have a question from a friend of the Law, Technology, and Warfare Research Cell, Seth Dilworth. He said, related to the previous question on debris, many practitioners consider potential legal recourse for debris issues. Do you think Article 6 could be applied as broadly as Article 7? Are there any instances of states applying either Article 6 or Article 7 broad enough to include debris?
The answer to the first part is yes. The answer to the second part is no. Twofold no. Let me explain. I think, and I've always made a pitch for that you can use Article 6 also to get compensated for space debris. Article 6, of course, provides that a state is responsible for compliance with international rules. I think we are about to be able to argue that causing space debris wantonly, although, of course, the recent Russian and Indian anti-satellite actions may tell differently. So we're still a little bit further away. I should probably backtrack a little bit on what I'm saying there. But if you can argue that wantonly causing space debris is causing damage, is a violation of an international obligation, then following the general principles of state responsibility, the state causing that damage is required to provide reparation, and reparation can well include material compensation for damage included. So that's the yes part. Where I get to the no part is that neither Article 6 nor Article 7 have been really applied in practice. Article 6, to start with, not at all. And I am, in my analysis and my works, I have repeatedly suggested that most people are not even aware of this possibility, because as soon as damage caused by space activity occurs, everyone focuses on Article 7 and the Liability Convention. But there might well be a cause for action outside of the Liability Convention, outside of Article 7, on the basis of Article 6, which nobody has thought about. But I'm afraid sooner or later that will happen. Hasn't happened yet. Even Article 7 and the Liability Convention have never been formally applied. There was a number of years ago, there was a dead Russian satellite, which had been run out of control for almost 10 years, which ran into an Iridium satellite, an operational communication satellite owned by the US company Iridium, causing it to blow up. And the dead Russian satellite was clearly space debris because it was inoperable, had no practical function. The Russians had lost control over it 10 years earlier. And we were lucky enough, because it was still a whole satellite, to be able to identify it as one of the Cosmos series. Nevertheless, the Iridium chose not to even try to get the US government to initiate proceedings against the Russians under the liability convention under Article 7. And part of the reason was that Iridium had chosen to launch from Baikonur. And there was a question whether, on the one hand, the United States would qualify as a launching state of a private corporation launching outside of US territory, not from a US facility. So there was a real question whether the United States would even qualify under the liability convention as a harmed state to issue a claim. And on the other side, because of the launch of Baikonur, you had Russia being a launching state of the damaging satellite, the Cosmos satellite, as well as a launching state of the satellite harmed. So to some extent, the liability convention didn't make too much sense. Should Russia sue itself as a launching state? So, and that was the closest we ever got to really a piece of space debris leading to a clashing into another space object, giving rise to these liability questions. So that's all matter for the future.